The U.S. Supreme Court on Wednesday ruled 7-2 upholding President Donald Trump's move to let more employers opt out of the Affordable Care Act mandate guaranteeing no-cost contraceptive services for women. The case involved a 2018 regulation from the Department of Health and Human Services exempting any employer with a religious or moral objection to contraception from a requirement that such coverage be included in an employee's health insurance plan. 17 states, led by Pennsylvania and New Jersey, challenged the policy as fundamentally unlawful and its rationale as arbitrary and capricious. The Affordable Care Act requires insurers to include preventive care and screenings as part of minimal essential coverage for Americans, but it left to HHS to define what services qualify. Since 2010, all FDA-approved contraceptives have been included. Millions of women obtain birth control at no cost through their employer-sponsored health insurance plans under these rules. Justice Clarence Thomas, writing the majority opinion, concluded that a plain reading of the law gives the administration virtually unbridled discretion to decide what counts as required coverage and any religious and moral exemptions that may be necessary. No language in the statute itself even hints that Congress intended that contraception should or must be covered, Thomas writes. It was Congress, not the administration, that declined to expressly require contraceptive coverage in the ACA itself. Chief Justice John Roberts and Justices Samuel Alito, Neil Gorsuch, and Brett Kavanaugh joined Thomas's opinion. Justice Elena Kagan filed a concurring opinion in the judgment, in which Stephen Breyer joined. Kagan made clear, however, that the fight over the exemptions may not be over. While the administration has the right to change the policy, she said, I question whether the exemptions can survive administrative law's demand for reasoned decision-making. That issue remains open for the lower courts to address. The Administrative Procedure Act requires federal agencies to consider their impact of regulations and provide a public rationale for changes to the law. The courts did not fully examine whether HHS complied in this case. Justices Ruth Bader Ginsburg and Sonia Sotomayor dissented, saying the court's ruling leaves women workers to fend for themselves. As the government estimates, between 70,500 and 126,400 women would immediately lose access to no-cost contraceptive services. Under the judgment, Ginsburg wrote, expanded contraceptive services coverage under the ACA has had a sweeping impact, say women's health advocates. The benefit saved women an estimated $1.4 billion on birth control pills in 2013 alone, according to the National Women's Law Center. Increased access has also been credited with reducing abortion rates nationwide.